just given, it's not often people are named multiple times, I suppose, as a personal representative, or they're not doing it until it's later in life anyway. So this is the type of thing that it's good to know a little bit about if you are a personal representative, or if you're named as one for down the road for a parent's estate plan, maybe, or a friend's estate plan. So again, as we get started here, I'm attorney Justin Randall with Hooper Law Office. Our topic today is about personal representatives paying bills during probate and kind of what steps need to be taken and what needs to be done before that can even happen. There's a lot of things that people do that when they're named, where maybe they think it's a lot more straightforward than it ends up being, I think, or than it actually is. It's not overly complicated either, but it's still something that they need to be aware of. If you're watching this live, just know that you can participate and ask questions. So there's a Q&A function that I can see in front of me here. So if you have any questions that come up related to the topic today, please feel free to submit those. I'll see those and we can answer them as we go along. Otherwise, you'll get a feedback form at the end of this that just gives you a place to mark down if you'd like us to ever set up a time to talk with anybody. We do offer free initial consultations. They're usually scheduled for about 2 hours. Just gives us plenty of time to talk. And then, usually by the end of that meeting, we're able to give a pretty good recommendation on what somebody needs to do, whether it's, setting up somebody's estate plan, or helping them with a probate, or with a administration of someone's estate, whatever it might end up being. We're able to usually give a pretty good recommendation by the end of those initial consultations. So we won't reach out to you unless you fill that out. So if it's something you'd like us to do, just please feel free to fill that out. And then, we try to do these weekly, and our topic next week, actually, if you remind me, is I believe our topic next week is common caregiver mistakes. Sorry, I had to look at that for a second. Caregiver mistakes, meaning, when someone's planning for long-term care, things that either people do when they're paying those caregivers, especially if it's a family member, or maybe giving to them, or how they're paying expenses. I mean, the rules are a little more complicated around that than people think, and sometimes they're not really common sense either. But anyway, so again, today our topic is paying for bills as a personal representative when somebody's using probate. So I guess the first mistake or misconception people have is that if they're nominated in someone's will as a personal representative, that when that person passes, they can immediately go down and start paying bills out of the bank account, right? Can go down to the bank and say, see, look, I'm in the will as a personal representative. Let me have access to this account. Well, the bank is going to tell you that that's not enough. And the reason for that is wills actually only control assets that are going through probate. And before someone can actually be named as a personal representative, or nominated, or actually approved by the court as a personal representative, they have to actually submit the will to probate. So just being named in a will is not enough. You have to actually have that approval from the court first to actually begin acting. So it's not as simple as taking it down to the bank and showing that, because really, when you're in someone's will as a personal representative, all that really is a nomination, right? It's the same thing with guardians for minor children. The people named in the will as guardians are not automatically going to be, no matter what, approved. The court still has to decide that person is fit and that there's no objections to that appointment as a guardian or as a personal representative. So once the will is submitted to probate, though, that process starts where the personal representative who is nominated, the court will make sure that what they call the interested parties are given notice. This is going to be a huge oversimplification, but the interested parties are essentially the people who are inheriting under the will, or would inherit under the will or under the estate if that will were invalidated for whatever reason. So it's mostly kind of the beneficiaries making sure that they're okay with that person being appointed. As long as they all sign off on it, it's a pretty quick, appointment approval. It's not, it doesn't drag out too long. It still might take a couple of weeks, just kind of depends. But if there's objections to that person being named, that can take a little longer. That because then they want to make sure that if those objections are valid, that person not be appointed, right? I mean, they're making sure that somebody isn't unfit for that role. You don't want someone committing financial, fraud or abuse to the estate, or stealing money in any way, or doing anything that would be against the wishes of the person who's passed. So if there's no objections at all, though, then it's a pretty quick process, as long as everyone signs off pretty quickly. So after that happens, though, that's when the court grants what's called a domiciliary letter. So the domiciliary letter is, I like to think of it as sort of like the power of attorney for finance of the estate in some ways, or at least proof that you are who you say you are. So then you can go down to the bank, for example, and if that account is part of the probate estate, that's when the personal representative has access to it. That's when they can start paying expenses and following the rest of the steps. So if somebody has like final hospital bills or funeral expenses that weren't prepaid for some reason, or come in after someone passes, those are the accounts that person has access to. This is where things can get a little more complicated depending on how the estate plan was actually set up to begin with. So the biggest misconception that people have about wills in general is that, anything in my will that I put down there, that's what's going to happen. That's what they have to follow this plan. That's only true if the assets that you leave behind for this kind of situation are actually going through the probate process. So a lot of people, there's bad information out there, or just kind of a misconception about what actually happens after someone passes away. But a lot of people think if you have a will, that means, my estate's not going to go through probate. There's no reason to actually have a probate open. That's only for people without wills or with no plan at all, right? But unfortunately, that's an incorrect assumption. Wills only direct assets that go through probate. So what a personal representative might run into as an issue is that maybe those accounts are all beneficiary designated to the beneficiaries. So when that happens, that is not necessarily a part of the probate estate. It actually will pay out directly to those individuals. Well, if one of those individuals is not the personal representative, and that's how all of the money goes, that personal representative may not have access to the finances to pay bills as the personal representative of the estate. The beneficiaries may have all of it. This is a really common problem that people run into, mostly because they're trying to do things what they think as the easiest way, to get them done, the simplest administration, but they end up often causing more problems than they actually solve. If that, like I said, one of the beneficiaries is not also the personal representative, the issue they're going to run into is they don't have the money to pay expenses from the estate. And, that's when they have to either try to ask for money back from the beneficiaries to pay expenses, which those beneficiaries are under no obligation to actually do because it's now their money. Or I suppose if it's a very good-hearted personal representative, they may try to pay out of pocket for some of those expenses and then hopefully get reimbursed from the estate. But if nothing is in the estate, everything's avoided probate, that's where it can be very difficult to ensure they will get reimbursed. So if you are a personal representative, or you're named in someone's will as a personal representative, that's when it's a really good idea before that person passes away to have a conversation and really work with the individual to help them understand what that actually looks like, because unfortunately it's pretty common where these things these types of misunderstandings create pretty big problems, or at least administrative difficulties at the very least for the personal representative. The other kind of side of that might be that the personal representative is also one of the beneficiaries of the will. Well, even if that's the case, let's say they are a beneficiary on an account. If you're the personal representative and all of the rest of the money's been paid out already and you've got your share as a beneficiary, you might try to pay those expenses out of your share of the estate because, well, I have funds available to do this now, so I'm going to go and pay whatever the expenses might be. The biggest issue there is that if, let's say, for example, somebody has 4 kids and they divide the estate 4 ways. Well, if only one of those 4 kids is the personal representative and they're using their share to pay expenses, there's again no guarantee that they will be reimbursed necessarily, and that their share of the estate is what was originally intended. So, I mean, it's not hard to see how if everything went 1/4, but only one person is using their fourth to pay for expenses, and nobody else chips in for those expenses out of their share, that 1/4 may have initially been 1/4, but now it's much less than the other three people got. And this is another situation where the other beneficiaries are not obligated to actually pay expenses out of their share. So that's where making sure, if you are the personal representative and you are able to have this conversation with somebody during their lifetime, helping them figure out how to make the estate actually estate administration actually function the right way. Make sure there's at least some sort of account available for you in that role, and as that role to pay expenses, not you as an individual, but you as the personal representative. That makes sure too that you're really separating yourself out as an individual from the actual estate. You're really acting in that capacity, not as the individual or as the beneficiary. And that makes sure too that you have the authority you say you do as a personal representative, that there's funds available for those expenses, and that after those expenses are actually paid, if there's anything left over, assuming that it's not a deficit estate, then only then do those shares actually divide out. So that makes sure that people actually share in their expenses equally, so that 1/4, as I mentioned earlier, actually ends up everybody getting the same amount, rather than it starting off as the same amount and changing over time because one person used their share of the estate. But kind of the last thing that I tend to see mistake-wise when it comes to setting this up is that somebody will name only the personal representative as the payable on death or transfer on death for everything. And that's just as equally disastrous across the board, because now that person is the beneficiary of those accounts. So whether they're also a beneficiary under the will, or maybe they're not at all, they are now the beneficiary, the only beneficiary of those accounts. So they are under no obligation then to share it with the beneficiaries according to the will, because it's now theirs. Once somebody receives something payable on death or transfer on death, that's just their money. So they don't have to share it. They, in theory, don't even have to use it to pay expenses, although that defeats the purpose of what that original plan was. But it just goes to show that things can really go haywire if people don't understand how their plans work. So assuming, though, that everything did go, or the vast majority of things went through someone's probate estate as and they're the personal representative managing things, and they have access to those funds, like all of those steps have been done properly up to this point, things are set up very, very well, and everything's running like clockwork. Well, then that's when you have to start thinking about how to pay expenses and what sort of steps need to be done to make sure that that's done properly. So it's not quite as simple as, okay, I'm just going to start paying off all the things I know about. There's certain notices you have to give to creditors as the personal representative for the estate. So generally speaking, you have to give direct notice to the creditors that somebody knows about. Like if I know that I have a hospital bill coming in for the estate from this hospital, I have to give them notice directly, not just sort of this nebulous public notice. But even if all of those people have been given notice, you still have to, for the estate, give public notice to any unknown creditors as well, any potential creditors. And this usually runs for about a 90-day period of time, where during those 90 days, creditors can come forward and make a claim against the estate, but they don't, if they don't come forward by the end of those 90 days, then their claims may not be admitted at all, or they shouldn't be at the very least. So at that point, though, once those are all known and everybody's come forward, then they are paid out in order of priority. And if somebody has like a secured loan, that, gets paid first, obviously, right? Those sorts of things. But it's no different in that sense, too. If somebody has a deficit estate, in terms of a bankruptcy, how that sort of works, where there may not be enough to pay everyone off, but that, at least as the personal representative, gives them some protection from personal liability of not having paid things the right way. It's actually a good idea to wait and pay some expenses. I mean, there's some, if it means like the heat for the home is going to go out and the pipes are going to freeze and all of this is going to happen. There are some expenses like that where you just have to pay those before those 90 days are up. But when, especially it comes to bigger expenses where it's like hospital bills or, even potentially funeral expenses, if those aren't prepaid, or any other sorts of, debts through a bank, a mortgage, I mean, things like that, it's actually better to not just pay those off right away before those 90 days are up. And the reason for that is, as a personal representative, not only is it your job to actually administer the estate, it's your job to make sure that the estate value is is the maximum value it could be for the beneficiaries. So one of that, sort of a component of that is making sure that you're not paying somebody who doesn't properly submit a claim against the estate. So if you've given the proper notice directly to them, or if they come forward after those, roughly 90 days are up, their claims are not valid anymore. They cannot come forward against an estate that they've been given proper notice and they never filed that claim. So that means then that you may not end up having to pay that bill. And I've seen this happen before where it was some hospital, I don't remember where the hospital even was. I don't even know if it was one that was anywhere near our area, but this bill was out there and they were given notice, and apparently the notice got buried on somebody's desk under a bunch of paperwork, and they filed a claim months after that 90-day period was over. Well, the probate court said, too bad, you came forward too late. You didn't come forward in time. It's not fair to be able to come forward as a creditor months after the fact, after this period of time is over. And then they ultimately didn't end up having to pay that bill. So that is potentially thousands of dollars that then goes to the rest of the beneficiaries. So as a personal representative, as I said, your job is to make sure the estate value is the best it can be for those beneficiaries, and not pay unreasonable expenses or potentially pay creditors that never followed the proper steps. So that's why it's not just, okay, now that I have access, let me go out and pay all of these expenses. It's making sure that those steps are actually followed properly, and making sure that if they don't make their proper claims against the estate, that you've done all of the things to give proper notice, and they don't come forward, that, too bad for them. They didn't follow the right steps. You did what you had to do, but they didn't uphold their end of that bargain. So those are the types of steps that you have to do in terms of creditors in particular. But as a personal representative, one of the kind of smaller things, but can end up having a big impact in terms of whether or not you're doing your job correctly, like I said, with that maximizing the value of the estate for people, is making sure that expenses are reasonable too. So if you're paying things on behalf of the estate, maybe you have to cover your travel expenses, reimburse yourself for those, because maybe you were flying in from out of state to do something and you had to do it on behalf of the estate. Well, that's a reimbursable expense, and you can get those sorts of things covered as long as they're reasonable. But when that reasonable is doing a lot of heavy lifting there. So I use this as an example a lot. If a personal representative or an executor of an estate has to come in and fly in to do their job, well, did they use the estate to pay for first class, or the first class ticket, or did they use it to for like the main cabin kind of ticket, or maybe the bare minimum? And if they're paying more than they should have into something, that's not a reasonable expense, right? And that could be an abuse of authority. So there's some extra precautions you have to take as a personal representative to make sure that you're not doing anything like that where it is unreasonable, because that's when the beneficiaries could potentially have a claim against you and say that was unreasonable, that was an abuse of authority, you didn't maximize the value of the estate for us, or that expense was exorbitant and just absolutely unnecessary, right? I mean, if it was a difference, for example, between I had to drive 2 hours versus fly, in a plane ticket, something like, or buy a plane ticket to fly into a city, right? That kind of thing. I mean, it can be kind of across the board. But you might not be fully reimbursed for unreasonable expenses, then is what that means. So when it comes to paying these sorts of expenses, really the biggest things to remember here are taking the proper steps to make sure that you actually have the authority granted through the court and that you're not just taking the will down to the bank, like I mentioned, and saying that you do. So that is the number one first thing to do, is make sure that the will is actually filed with probate. Otherwise, it's not going to give you the authority you need just by showing the document to the bank. They don't care what that says. They need the probate to actually be open, the estate to actually be probated. After that, making sure that you work with somebody or make sure that you understand how to how to file those creditor notices and make proper notice, and that the deadlines and all of that, and pay them as they come in, when they actually submit a claim to the estate. After that, really making sure that the beneficiaries' shares are maximized and making sure that they get the value they're supposed to, and that nothing is kind of untoward or no unreasonable expenses are being incurred by you as the personal representative that shouldn't otherwise be an expense of the estate. Those are really the biggest things that as a personal representative you need to be aware of when it comes to paying bills. I also mentioned too, and this is really more on not you as the personal representative, but on the person who's actually setting up their estate plan. It's really important that they understand how probate actually works and what, where things actually go when it comes to things like beneficiary designations, or, do they actually have provisions in their will that they need followed? Do they want to make sure that the expenses are shared equally, or, do they understand that as a payable on death or transfer on death beneficiary, that those people are under no obligation to actually pay into the estate, because now it's their money. So you could, if this is your estate plan we're talking about, you could be putting someone in a really bad position if you are naming them in this role and they accept that position as a personal representative, but then you don't provide them with funds to pay expenses. It puts them in an awkward position of potentially having to try to request money back from beneficiaries, which again, they don't have to do. And it makes their job very difficult. One of the last things I'll leave you with too is that, for example, what we see a lot is maybe it's the real estate that goes through probate, right? That's the most common asset you would see having someone, probate through their estate. Because there's generally not a transfer on death or a payable on death for real estate. There can be, but it doesn't make it the right plan for somebody either. So the home is in probate. There's ongoing expenses for the home. There's, like I said, heating bills, cooling bills, water, utilities, things like that, property taxes potentially, if the probate takes long enough and that time of year comes around. Maybe there's hiring a realtor as an expense. I mean, whatever it could be, there's expenses, and there always are. But if that's the only thing in probate, no money, no accounts, nothing else is going through probate, that puts that personal representative in a really tough spot again, because where do they get the liquid funds to pay those expenses? If it's real estate only, are they using their own expenses to do that? Again, they could get reimbursed, but there's never that guarantee if there are other expenses that eat up the rest. So if you have a will that you're intending to use, it is essential that you actually make sure some amount of your estate goes through probate, or at least the vast majority of it does. There's certain assets that you wouldn't do that with, like IRAs or 401ks. I mean, those types of qualified accounts. And there's rules around that, why that would not be ideal. It can force a 5-year payout, for example, for those accounts for beneficiaries. So that wouldn't be ideal. But if you have an estate mostly comprising of like your home and maybe some life insurance, some bank accounts, traditional investment accounts, I mean, there's no reason, for example, if you're intending to use a will, that those don't go through probate to follow the will. So that's more advice for just someone setting up their estate, but it ties so heavily into what a personal representative needs to actually understand and know about paying expenses, that you need to know, as someone setting up your own estate plan, that if you put someone in that position, you want to set them up for success. You don't want to put that burden on somebody to be that personal representative if you're not going to help ensure that they actually have the resources available to do their job properly. You don't want to put someone in a position where they have to try to ask beneficiaries, to chip in for expenses or give money back to the estate. because that can also create tension and problems amongst, interfamily relationships too. And one of the other goals of estate planning is always to make sure that we avoid conflict as much as possible within families, because it doesn't do anybody any good if an estate plan tears the family apart, right? So as I mentioned, our upcoming topic next week is our common caregiver mistakes. So if you are a caregiver or you are paying a loved one to provide care for you at home, this is a really good one to attend or watch, because there's a lot of things in that presentation that I don't think a lot of people are aware of when it comes to what counts as a gift for Medicaid, for example, or the other problems that can come up with paying a loved one for care. Or how they're paying that loved one for care can be another big problem. So that is a really good one coming up next week. I don't see any questions, so I will let you all go. But thank you for attending, and I hope to see you guys next week.